Be ready. Start. The petition invoking Article 32 of the Constitution has been filed by former civil servants, scholars, activists, and experts in fields such as international relations, human rights, and policy analysis. The petition seeks direction to the Union government to cancel existing license and permissions and to halt the grant of new license to companies in India for the export of arms and military equipment to Israel during the ongoing conflict in Gaza. These companies, as the petitioner described, include a public sector enterprise in the Ministry of Defense and private companies which have allegedly been granted license after October 2023. The petitioners claim a violation of India's international law obligations and of Article 14, 21 and 51C of the Constitution. Para. Supporting the submissions of the petitioners, the Learned Council has relied on the rulings of the International Court of Justice allegedly into the conduct of Israel in Palestinian territories. The submission is that India is bound by international treaties which disallow the supply of military weapons to states who have engaged in war crimes and genocide. In other words, the submission is that the continuation of the export license would constitute action complicit against the Genocide Convention and other international obligations which India has assumed. Para. The fundamental objection to the maintainability of a petition of the nature that is before the court lies in the fact that the authority and jurisdiction in relation to the conduct of foreign affairs is vested with the Union government under Article 73 of the Constitution. Apart from Article 73, the provisions of Article 253 of the Constitution stipulate that Parliament has the power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement or convention with any other country or countries or any decision made at any international conference, association or other body. Para. There is presumption that international law is a part and parcel of the law of the nation unless the application of a principle of international law excluded expressly or by necessary implication by the competent legislature. However, the basic issue which falls for consideration in the present proceedings is whether the court under Article 32 can issue a writ to the Union government to cancel existing license and halt the issuance of new license for the export of arms and military equipment to Israel. We are positively of the view that the answer to this question must be in the negative for more than one reason. Para. First, any grant of relief in the present proceedings is suggested on the submission of the petitioners in regard to the conduct of an independent sovereign nation, namely Israel, in the conduct of its operation in Gaza. The sovereign nation of Israel is not and cannot be made amenable to the jurisdiction of this court. Hence, for this court to consider the grant of the relief as sought, it would inevitably become necessary to enter a finding in regard to the allegations which have been leveled by the petitioners against the state of Israel stop.